What should you do if you get injured on the job? How much money can you get for that injury? How should you report that you got hurt at work? Should you even call a lawyer? And most important of all, how do you fix the safety issue so that it doesn't happen to anybody else? My name is Brandon Robertson, and I'm an employment lawyer. In this video, we're going to answer all of those questions, so keep watching. This is the final video in a 4-part series called Workplace Safety for Employees. In the first video, I detailed your legal rights to a safe work environment. The second video was about how to report an unsafe work environment to the company. The third video was what unlawful retaliation looks like and the money you could win in a retaliation lawsuit. And this video today is what you should do if you get hurt on the job and the money that you could win for your injuries. But before we get back to the whiteboard and all the details, I need to discuss a few quick things. Number one, I have a license to practice law in California, but I'm making this video for workers across the country. This video covers some basics, but it should not be taken as legal advice for your situation. The law differs from state to state, and I don't know anything about your situation. You should never take what is said on an internet video as legal advice. If you need legal advice, pick up the phone and call a lawyer in your state. Number two, I'm going to talk a lot today about workers' compensation, but I'm not a workers' compensation lawyer. I'm an employment lawyer, which is different. Employment lawyers do things like wrongful termination, discrimination on the job, harassment, retaliation. In contrast, workers' compensation lawyers help people in the legal/insurance claim system set up by your state to compensate employees for workplace injuries. So if you need specific advice regarding an injury, I recommend you call a workers' compensation lawyer in your state. 3. If you are in California and you have an employment issue, feel free to call me for a free consultation. But let me be clear, the free consultation process at my office is primarily for California workers who got fired and they believe they have a case for retaliation, discrimination, or wrongful termination. All right, with all that out of the way, let's get back to the whiteboard. Big picture. After an injury at work, you become a problem for a lot of people. You suddenly go from an asset that makes the company money to a potential legal threat, right? Second, you're about to cost the company actual money because as soon as you file your workers' compensation claim, the company's workers' compensation insurance premiums are going to go up. Also, your boss is likely to be upset with you because he or she is going to have to scramble to find somebody temporarily to put in your position on short notice to keep the business running. And the more skilled or upper management you are, the more difficult that becomes. Also, your coworkers are likely to be upset with you because they're now going to have to pick up the slack while you're out recovering. And finally, when you do come back, human resources is likely to watch you like a hawk and write you up because they're much more likely to blame you for the injury rather than take responsibility for the condition that caused it. Long story short, if you get hurt, you should expect that nobody is going to be happy with you. Getting hurt at work can start a chain of events or a snowball of events that you cannot control. This video is about how to mitigate those consequences. I will also discuss how to legally protect yourself so that if your employer decides to break the law, you will have all the evidence that you need to give to your lawyer. But before we get to the details on the whiteboard, let me ask you a quick question. Can you take a moment and tell me what is the worst injury you've ever seen on the job? Tell me your story in the comment section down below. Those comments help everyone see the world for what it really is, rather than what we believe it to be. First, we must talk about workers' compensation. Workers' comp, as it's usually known, is a legally mandated insurance system that provides workers money and medical benefits when they get injured on the job. Under this mandatory system, you do not have a right to sue your employer for negligence or personal injury. Every employer is legally required to carry workers' compensation insurance, and if an employee gets hurt on the job, the insurance company is supposed to pay for medical care and lost wages. This is a mandatory system that all employers and employees are subject to. You cannot opt out. Just a moment ago, I said that you cannot sue your employer for negligence if you get hurt on the job. The only exception to this rule is if you get injured by a third party's negligence while on the job. So for example, let's say you're working in a factory. If a robot that was manufactured by a different company malfunctions and negligently injures you, you can hire a personal injury lawyer and sue the robot manufacturer, and you don't have to go through the workers' compensation system. But let's talk about some of the problems with this system. The big problem with workers' comp, just like any insurance system, is that when an injury happens, the insurance company wants to pay you as little as possible for your lost wages and medical expenses. That is how they make their money on the difference. They do this in three main ways. Number one, they often deny legitimate claims. Number two, they always try to funnel you to their preferred doctors who are often bad. They're in their pocket, and they have a financial interest to provide you as little treatment as possible. And three, the workers' comp system has a predetermined payment amount for specific injuries, which does not adequately consider the difference in the impact the injuries have from person to person. But despite these drawbacks, it's a mandatory system. So if you get hurt on the job, you must play the workers' compensation game to get what you're legally entitled to. So how do you do that? So how do you play the workers' comp game? Well, number one, if you got hurt at work, you need to immediately ask HR for a workers' compensation injury claim form. Fill that form out and submit it following the directions. Do not delay doing this. It's very common for unscrupulous employers to tell you to avoid filing it or delay filing it. This is a mistake that could haunt you later. Now, after they receive it, if the insurance company is acting in good faith, they will do two main things. Number one, they will get you to a medical provider quickly. And number two, that doctor, that provider, should do a good job examining you and diagnosing the injury and setting up a treatment plan. Far too often, people report back later that the doctor was dismissive, patronizing, and avoided doing things like MRIs, X-rays, and other appropriate diagnostic measures. And two, if you sense any kind of funny business, be prepared to call a workers' compensation lawyer. I am not a workers' compensation lawyer, but I've talked to enough to know that you should call one when one or more of the following things is happening. A, if the employer is being difficult, such as not giving you the claim form or putting extreme pressure on you to avoid filing a claim. B, if the insurance company is being difficult, such as denying your claim outright. In most states, they have 90 days to accept liability or deny it. C, if they are not sending you to get appropriate treatment, obviously call a lawyer. D, if the doctors are being shady. Workers' compensation doctors are very conservative, sometimes awful, because they often have an economic incentive not to do more testing or more treatment. They often refuse to document the injury completely. It's very common for torn rotator cuffs and other ligament tears to often be diagnosed as sprains. So if you suspect you are not getting the care that you need to heal appropriately, then I recommend you call a workers' compensation lawyer as soon as possible. Often the biggest benefit that a workers' comp lawyer brings is that they fight to get you the treatment that you actually need to heal. Obviously, you shouldn't be calling a workers' comp lawyer if your injury is really minor and the recovery is just a day or two. Moreover, the workers' comp lawyer is unlikely to be able to recover anything significant on tiny injuries. Well, okay, so how much will you get paid? Before we talk about money, we need to discuss a few other things. If your injury was due to an unsafe condition or situation at work, I strongly recommend that you submit a safety complaint to Human Resources at the company in writing. The second video in this video series goes deep into how to do this and why. If you haven't seen that video, I recommend that you go back and watch it after you finish this one. But why should you submit a safety complaint? Well, there's two main reasons. Number one, if you've been injured at work due to something that is unsafe, I think you have a moral imperative to report it and try to get it fixed so that nobody else gets hurt, right? You will protect other people if you do it. Number two, now that you have been hurt and you're going to be out of work and you're probably going to file a workers' compensation claim, you're going to have a target on your back, right? It's very likely that your coworkers, boss, and employer are going to be upset with you, and you need to legally protect yourself. The best way to do that is by submitting an appropriate complaint in writing to the most appropriate authority at the company. That way, if they do start retaliating against you in some way, you will have a good legal argument that they're targeting you because you spoke up after an injury and they're trying to get rid of a problematic employee. Now, I go, again, into much greater depth in video number 2 in the series, so I really want to urge you to go watch that when you finish this one. Also, if there is an OSHA violation that was involved in your injury, or some other statutory safety violation, then the worker might have an add-on claim to their workers' compensation claim, wherein they could earn additional money for the violation. It's called a serious and willful claim. On top of that, in California anyway, if the employer retaliates against an employee for filing a workers' compensation claim, another add-on claim exists called a 132A violation. While this isn't as powerful as the normal employment retaliation laws, it exists within the workers' compensation system, which is helpful because it can help facilitate settlement. Often injuries lead to disabilities. We all know this. But what most people don't know is that there's an entire body of law called disability discrimination. That body of law says that it's unlawful for an employer to terminate an employee because he or she has a disability, so long as the employee can perform the essential functions of the job. And this body of law usually requires the employer to provide the employee with what's called a reasonable accommodation, if needed, to help him or her perform the essential functions of the job. So if you become disabled due to an injury, I recommend that you get a doctor's note and inform the employer about your disability and request any reasonable accommodations that are necessary for you to do your job. Why do I recommend that people do this? It's the same as before. After you have an injury, you have a target on your back. Informing the company about your disability and any reasonable accommodations that are necessary will further protect you in the event your employer decides that they want to get rid of you. I go into much greater depth on this subject in my disability discrimination and reasonable accommodation videos, which I will link in the description down below. Similar to that, if your injury necessitates that you take an extended leave of time off of work, you may qualify for the Family Medical Leave Act, FMLA, or CFRA, which is the California equivalent. Generally, if you qualify for a leave of absence, you can take 12 weeks of unpaid time off to recover from the injury. The employer is legally obligated to let you return when you come back. They cannot fire you. I've made detailed videos on both FMLA and CFRA, so if you want to know more about either, you can find links in the description below. I recommend you watch them when you finish this one. Well, okay, that is what you should do if you get hurt at work. If you have any general questions about what I've said in this video, please ask them in the comment section down below. If you know anyone who should watch this video if they got hurt on the job, please share this video with them, share the love, okay? Also, please remember I'm a California employment lawyer. I help employees with things like retaliation, wrongful termination, discrimination, serious things like that. I am not a workers' compensation lawyer, so if you got hurt on the job, please call a workers' comp lawyer. Now, if you want to call our office for a consultation, please be respectful of our time. The free consultation process at my office is primarily for California employees who got fired from their job and they believe they have a case for retaliation, discrimination, wrongful termination, things like that. Also, please subscribe to my channel for more videos. If you want to watch more videos about employee rights, I plan on making a lot more in the future. I hope this was helpful. Take care.